Ali musati ya bukugu baba wangu. Allah barakatuh. Allah yafe. Jadi nabo. Alhamdulillah ya Rabbi.
Arising out of session case number 1 of 2017, we have Jamir Mukulu.
The complaints are being made about the people through whom they can come.
You can write to your lawyer.
Yes, but they will not allow me to bring it to him. They will not even allow him to take it. Yes, that has been the practice. They don't allow anything to get out of prison before they look at it.
Okay.
And once they
I'll give you 5 minutes. Please go ahead.
Of course, the 5 minutes are not enough.
But
I've got 4 issues. One, I'm being tortured in prison. If, Mr. Judge, you lock a person in a 2.5 square meter room cell with virtually no ventilation, except for a small ventilator about 6 meters up. And the outer part of the ventilator, there is a brim that when wind blows towards the cell, it hits the brim and collapses, so it does not enter the cell.
So
those
air saturation is the issue.
Sorry?
Air saturation.
Yes, but it is important because I'm already suffering from lungs problem. And in that room, that cell has so many mosquitoes. If you looked at the walls, you could see they are all tainted with blood. And you keep him inside that cell with a bucket of feces and urine stinking through the whole night. Keep him there for 15 hours, sometimes 16, sometimes 17, sometimes 18 hours. Sometimes the temperature is so high to melt a Vaseline. There are bed bugs, there are lice, there are even some small lizards. You keep that person in that cell for 15 hours every day for 10 years. Mr. Judge, is that inhuman treatment? Is that humanization? Is that torture? Is that lawlessness? The next point is concerning that, but of course the points are so many. The second one is about they deny me toilet access, while the toilets are just in 5 minutes. In 5 meters. They use the toilet, and in the morning they defecate on the floor of the toilet. In the morning I have to clean the toilet. They are scats themselves. Why they deny me access to the toilet when the toilets are there?
Is it a staff toilet or prisoners?
Prisoners' toilet, but they use them in the night. The second issue of Mr. Judge is death threats. Attempted assassination. They have attempted to assassinate me. On the 9th of September 2016, those were 3 days after my arrival at Busira. Yabashai, the CGP, sent a team of his lieutenants. The team leader was one Akankunda. He told me that he had come with 2 messages from Yabashai. One was that whatever issues I encountered during my stay in Busira, I should not complain to him because he is the one who must have sanctioned me. That was the first message. The second one was asking me how many I mean, what are the names of the 2 visitors that had allowed me to get twice every month? And then Akamponga went on. Mr. Judge, I was trapped with COVID-19 and I nearly died. I exhausted about 8 cylinders of oxygen, and I spent almost 2 months in the hospital. Since then, I developed full-fledged high blood sugar, and high blood pressure. The doctors recommended, in fact, prescribed foods that I must avoid, and the foods that I must eat. Mr. Yabashaja, through his men, denied me access to that food until now. I cannot afford to buy food. I cannot afford to buy sugar at 10,000 shillings when it actually costs 4,000. I cannot afford to buy matoke at 35,000 shillings when it actually costs 8,500. I cannot afford to buy granuts at 15,000 when it actually costs 6,000. So I had to give up. I now survive on handouts and begging, and sometimes I work. I cook for someone, then he gives me a portion. Even the portion he gives me, I eat once in a day. The portion he gives me is not enough. I don't get satisfied because I don't get enough food, because the food is not really in my hands. I have lost weight. I was 101 kilograms at the time I stopped buying food because I could not afford. They hike the prices so that I cannot afford. I cannot afford to go. And I had to abandon because my family could not afford. So I don't get food.
Where do you buy the food from?
My family, all the prisoners, because they forced my family to give them money. My money, to give them my money. So they cut off the way they wish. That is depriving me of food.
So
I lost about 20 kilograms, Mr. Jack, because of not getting much food. The reason,
Because you're giving prices that
Yes.
instead of paying 8,000,
Yes.
you're supposed to pay 30.
yes,
So where is that?
I don't know where they buy the food from.
so it's your family that buys.
No, it is not. They refused my family to bring me food. They used to bring me food before even the doctor prescribed the food. So now they told them, you give us the money. We cannot allow you to bring here food. That was prescribed by the doctors to help me in my health problem. So they took away the money. They cut off the way they wish. A bunch of banana that costs 8,500. We can see that in the program of Akatari. Yes, Akatari. It costs 35,000. I mean, it costs 8,500. And avocado that was prescribed by the that costs just 500. They cut off 3,000.
My understanding is that your family gives money to prison authorities.
They don't give it spontaneous. They force them.
Wait, let me understand. They give money to the prison authorities. Then the prison authorities tell you how much it costs to buy food for you.
Yes,
Is that what is going on?
yes. But
It came to a point where your family could not afford it anymore because of those indoor prices.
yes. So I could not continue, Mr. Jack. I request that in order for me that food to be allowed to be brought in by my family. Because I cannot afford, I cannot continue begging from an income. Mr. Jack, not allowed to talk to any prisoner. If any prisoner, even if say Assalamu alaikum, he will get beaten. I'm refused to talk to even those among those with whom I'm on the fire. I'm not allowed, the co-accused ones, I'm not allowed to talk to them. Because I'm in isolation. In Lusirapa prison, there is a section called instrument torture cells. There are about 20 cells, but there are only 2 inmates in those cells. The other 2 are state agents. So all the others are in
How do you know that?
that what?
They only to the distracts.
They say it. They say it publicly.
But they live as prisoners.
Yes, they disguise as prisoners. They say it.
Your time is running out.
Is isolation, Mr. Yet the other point was about isolation. When other prisoners are still interacting with one another, watching TV, watching football, not allowed. I don't even go when the judges are visiting, between 7 a.m. up to 4. While other prisoners can continue watching and investing in so many activities, playing with draft and whatever, up to 10 p.m. when I'm locked up at 4 p.m. The last point is about the interference with my case. Prison News Authority has interfered with my case so much to the extent of editing the documents that I sent to my audience. They even refuse to censor or to allow the documents that they have not looked into in my absence. They insist that I must be absent for them to censor. What do they intend behind that? To take photocopies from the documents. Last time in 2018, Judge Swata told us that there must be privacy. The Constitution provides for privacy between the client and the lawyer. But they refuse even to allow me to give them documents concerning my case because they have not censored it. What is censored? They want to read through it and then take photocopies from it. We have made complaints to the Judge Swata the other time we were here. And she said that this has been a persistent complaint from the prisoners. They interfere with the communication between me and my lawyers. They sometimes harass them. They chase them away. Semakadi was chased away. Ocheng was chased away. Kasumba was chased away. Even they refused them to come with documents. Because the other time when Council Pale was bringing me these petition documents, and they refused him to come up with them. They retained them at the gate. They did not allow him until he had stayed so many hours in the prison so that they allowed it to come in. So, Mr. Giaga, I request that you stop them from harassing my lawyers, because my lawyers will be disgusted and frustrated and maybe abandoned.
Okay, that's your time. Your time is up.
By then, when we
just wanted to make a clarification. Whereas the third applicant did not file an affidavit in respect of the amended motion, and therefore did not participate in the amendment, is the original application to which he has an affidavit. When we applied to amend, he was not part of this proceeding because he was not present. I just wanted to clarify because there was a question as to whether he filed.
So what is the clarification? Because this is our current pleading right now.
Well, in which case then you would not be having a third applicant.
That's the point.
If that is the point. And
Because that's the point.
yeah, that's where I was seeking your guidance. Or maybe for the record as an officer, I just want to point out that in respect of the amended one, it does not deal with his original application because it has never been disposed of.
It has never been disposed of, but you amended the pleadings, in which you included him, but did not include his pleadings. Included his name,
Yes,
but no affidavit in support or mention anywhere.
that's correct, my lord, because you were not filing a fresh one. We weren't amending the existing one, which is part of it. But I'm not his lawyer, so I do not intend to add his case.
Doesn't seem probable. Kumar, what is your position? Mr. Pijan.
ensonga y'okuba nti tolina lawyer okyogera kooti.
No.
Whether a person who has not amended his application will proceed or not.
Is your position that you're going to amend in respect of first
That's my
applicant,
position.
second applicant?
Yes.
Only.
Otherwise, with respect to the third, his application remains as original. That's our view.
Yeah.
Amendment to your guidance.
cannot start instructing himself to present the person who has not instructed him and speak on his behalf. But when we had the conferencing meeting, his lawyers and the team which is here, it's them who asked court that they needed to amend. Actually, you informed them, I remember very well, Honorable Justice on your left and the one on far right were in court and are the ones who chaired the meeting. And they instructed them to go back to their clients and confirm if they still have instructions even to present them. It is even them who applied that they needed to amend their application because situations and circumstances had changed. And the amendment was done. And there was a consent that a new application be filed. A new application was filed, and there was no affidavit in support for the third applicant. I don't want to hold out to be representing him, and neither should anyone hold out. But the law is clear when an application is in court and it's not supported by an affidavit, it cannot stand for that particular person. In the circumstance, I pray that the third applicant is expunged off because he is not part of this application. If he feels that he has issues to raise or he wants to file an application, all rights are his, he can file his own application separately. But as of now, he has not filed enough letter to support, no submission, so we cannot proceed with it.
Address the court on the issue of the fact that he has not amended, that the amendment is in respect of one of the first two. What's your submission on that?
It's not true that he has not amended. They withdrew that application and filed a fresh one.
And they withdraw his behalf.
He was well represented in that conferencing meeting. His lawyers were there.
Approached to represent the third applicant. We have never represented the first applicant, the third applicant, sorry. Number two, there is no second application. Actually, there is only one application which was amended by the first and second respondent, and that is miscellaneous application number 21. Even the number never changed. With immense respect to my learned friend, if somebody has not amended the pleading, but has not withdrawn his pleading, he remains stuck with the first pleading. You cannot strike out the original pleading because someone has not opted to amend. No, you deal with it as it is. So my view, Lords, is that with respect to the third respondent, as third applicant, you can only hear his case as per the original motion. Because you can't coerce a person to amend his pleading. I remember well that at the conference, he was not representing his team. We clearly mentioned we were representing the person. And then also to bring it in context, at that conference, we were not even dealing with the application. The conferencing was for the trial, was in respect of the criminal case. That we only applied that there is a subsisting application to which we want to amend. And in respect of truth.
By your own pleading, where you have consistently talked of the applicants.
Yes, sir.
Not the first and second applicant.
I have only two applicants.
Your amended application
Yes, sir.
has 3 applicants, and the amendment appears to refer to the applicants who are the 3 applicants.
Oh, yes. see, my lord, is that probably the additional that respondent is I thought because the application I was amending had 3, that the application, the heading of the application will not change. Otherwise, when you go to the body, I do not in any way refer to the sign. I actually specifically mentioned where we are referring to individual applicants, including first and second respondents, applicants.
No, that's not the condition, Mr. Samuel. This application, the amended pleadings, are in respect, we find that they're in respect of the first and second applicants. The original application, not the original, but the unamended version, includes the third respondent and the third applicant, who is self-represented.
Yes, my lord. When the court, my lord, inquired from the accused persons, I'll just fill out the term paper. Sorry, it's super sensitive. Like super sonic. So, my lord, when the registry, in preparation for this case, contacted all the accused persons, that is the 38 of them, A93 indicated that he did not have an advocate. For that matter, the registrar appointed Counsel Khaled Alaka to represent you. And Counsel Khaled Alaka was present during the conference. And he was also in this and communicated that he was here. So I don't know if he's partner in joining Counsel Evans, maybe has his instructions, but that is what you have.
This is contained in the amended motion. And we are only going to highlight specific points of interest. But this application is based on 2 limbs that feed into each other. The first limb relates to jurisdiction and admissibility of the charges, with an interlinkage into adherence or otherwise to the tenets of a fair hearing as enshrined in our Constitution. The foundation, my lord, for the substantive provisions of our Constitution lies with the national objectives and directive principles of state policy, and in particular, objective number 5 that relates to fundamental and other human rights and freedoms, where the state is required to guarantee and respect institutions which are charged by the state with the responsibility for protecting and promoting human rights and providing them with adequate resources to function effectively. Our first contention, my lords, to support our application and therefore make a case for striking out the same relates to indictment exceeding extradition. From the facts in the pleadings, my lords, the 2 applicants, 1 and 2, were indicted for specific charges and counts. I refer to the proceedings in the Tanzanian courts in respect of the 2 applications that precipitated the extradition of the 2 applicants, wherein the first applicant was extradited in respect of miscellaneous application number 14 of 2015, and the second in respect of number 15 of 2015, my lord. You may be pleased to refer to page 4 of our submissions where we talk about the tribe with any offense and count beyond those for which the applicants were extradited is a nullity in our submission. And I refer to page 5 of our submissions where we raise the issue of whether the trial of the applicants is a nullity, and here specifically first and second, is a nullity for offending the Extradition Act and the speciality rule. I wrote the speciality rule is to the effect that a person cannot be charged with offenses other than those for which he was extradited, and refer to section 15 of the Extradition Act, Cap 124. And the summary therefore is here that a prosecution mounted and that proceeds on a flagrant disregard of an express statutory prohibition is unlawful, grossly unfair, and incompatible with the rights to fair hearing, which is an integral component of the due process of law. I refer to Article 28 of the Constitution and 44 of the same Constitution, which guarantee that right to fair hearing as a non-derogable one. The section reads, where, in pursuance of an agreement with another country, any person accused or convicted of any crime described in the schedule of this act is surrendered by that country, that person shall not come until he or she has been restored or had an opportunity of returning to that country, be tried or tried for any offense committed prior to the surrender in Uganda, other than such of the crimes as may be proved by the facts on which the surrender is grounded. My lords, the affidavits of the two applicants, together with the attached proceedings in Tanzania, are explicit that applicant number 2 was extradited on account of an alleged murder of one Modangu, and the first applicant was extradited on account of 7 alleged murder counts. In our submission, therefore, and consistent with Article 101 of the Rome Statute, which reads, a person shall surrender to the court under this statute shall not be proceeded against, punished or detained for any conduct committed prior to the surrender, other than the conduct or course of conduct which forms the basis of the crimes for which that person has been surrendered. B. Provides that the court may request a waiver of the requirements of paragraph 1 from the state which surrendered the person to the court, and if necessary, the court shall provide additional information in accordance with Article 91. Now, the Rome Statute, the Extradition Act, place a statutory and codified bar against any prosecution beyond laws. My lords, you will appreciate from the proceedings in Tanzania with respect to the first applicant that the magistrate was even forced to adjourn proceedings, inquire into the charge sheet, and receipts will never be prosecuted for anything beyond those offenses which were mentioned in the proceedings. You may be pleased, your lordships, to refer to the cases cited in United States versus Rocha, 19 U.S. 407, an 1886 case, where court recognized this rule to the effect that the defendant would be tried only for the offense with which he is charged. And this was found to be true in the state of Washington versus Martin Chopin. Again, my lord, I'm referring to page 8 of our submissions, that the Supreme Court answered this question in the affirmative, concluding that a person who has been brought into the jurisdiction of the court by virtue of proceedings under extradition treaty can only be tried for the offenses described in the treaty and for the offense with which he is charged in the proceedings for his extradition. The Indian jurisprudence has the case of Salim Abdul Qayyum versus CBI, which is also referred to, and they are all contained. I'm referring now to authorities number 1 to 3 and 4 in our band of authorities. My lords, that is the principle.
During his stay or their stay at California, were they being presented before court on a regular basis?
Yes, my lord, and presented.
Demanded.
Yes, my lord, and there's evidence of the court record. It's there. They were presented to court several times.
As the normal remand prisoners are treated.
Yes.
So there was no violation of
There was no violation. There are no
during
duties.
that period.
Not at all. On issue 4, I indicated that, my lord, there is no evidence adduced by the first African that his property was taken. As we indicated, we did not participate in his arrest. We only picked him from Entebbe. That is where the state of Uganda started participation involved with him.
How can taking property of the suspect stop a criminal trial? Supposing this property was taken, how does it affect the integrity of the trial? That is the test.
And
Because if you lose sight of that test, you will include many things that are irrelevant. You must isolate those occurrences which are so gross that they impair the criminal process. That is the test. Otherwise, all those other violations are handled as claims for civil remedies, compensation, remedies, restitution. Those are the remedies for those violations.
Which is a question for the applicant.
So you don't even have to respond to such until you are satisfied that what they are raising is a likelihood of a court finding that it is so gross as to impair the trial.
Most of right.
I think you've covered whatever you need to cover.
I'll go to the last issue for remedies available to the party. We respectfully submit that applicants' allegations or violations of their right fair hearing, freedom from torture, inhuman or degrading treatment are unsubstantiated and devoid of merit. The respondent categorically denies the claims of torture and procedural injustice, emphasizing that the applicants have failed to adduce credible evidence to support such allegations. These claims are speculative, baseless, and appear intended to distract this court from serious criminal, intended to distract from serious criminal charges the applicants are facing. Without conceding any violation in the respect, the respondent submits that if this court is inclined to consider the applicant's claim of violation of their right or personal liberty, the court should adopt a reasonable approach based on established jurisprudence. We refer to that case of Issa Wazembe versus Attorney General, where the applicant was compensated 50 million for illegal or incommunicado detention for 10 months, and for them, they alleged 12 days. Even then, because such can be compensated for, it cannot merit that reasonable ground for termination of their criminal trial. The applicants should be arraigned in court. They should face trial, which would be fair, speedy, so that they can answer for the charges slapped against them. In this instant application, the applicants have not demonstrated any harm resulting from their alleged detention. The respondent maintains that any delay in presenting the applicants before court was instated by the complexity and sensitivity of the investigations and carried out in good faith. Should this honorable court find merit in the applicant's claim for violation, this court should consider that the offense of terrorism and terrorism financing that the applicants were charged with are complex and grave offenses that threatens national and global security, and it is noteworthy that the applicants have not provided any cogent
response to that, but I would also like to warn the court against dealing with a matter which is already before the Constitutional Court. And my lord, the questions you are raising were still raised before the Constitutional Court at the hearing of that matter. But to answer you briefly is that the Human Rights Enforcement Act was not a government bill. It started as a private member's bill. And some of the questions that were raised, or what we told the Constitutional Court was, and we gave evidence that the Attorney General advised and gave comments on that bill. Those bills were not, the comments of the Attorney General were not considered. And that is why, my lord, the Attorney General raised a reference to the Constitutional Court in the case of the account.
It was initiated as a private member.
Yes, my lord.
Supports your argument that there is mala fights in what they are doing. They do all these offenses, of course, but we are aware one category of offenses will not pass extradition. Presented, they keep it until extradition is done. Now they bring it up.
Mr. Lord,
That would support your argument. This is a manipulation of the system.
This is exactly, my lord, that what I'm saying. You have put it in better English. But it goes beyond that. Even if I were to address the two names, the first one offense of but even another one which is conjured in bad faith to relate it, or which is interrelated and interlinked, and was known to the state. But also it doesn't stop there. Once you set a process in motion, you must act in good faith, especially if you're dealing with the process of court. Because court should not condone malafide. You go to court. And what the Attorney General of Uganda, Honorable Frederick Buhini, used to convince court to extradite were specific. He said, actually, those additional charges you're talking about, which you are seeing, were included in error. We have actually applied to court to strike them off, and they have done so. And you convince court. You're bound. Anything else that you do, you are amending the proceedings of court, retrospective. And nobody is allowed, by law, common sense, and even the decency of nations. My lords, I have answered the question of whether it is actionable or not. It is actionable on the part of the applicants. It is true that the Extradition Act was enacted long before the 1995 Constitution. It is also true that Article 274 provides for modifications and adaptations to existing law. But for what purpose? It doesn't stop there. To bring them in conformity with the Constitution. Is it said that this section was not in conformity with the Constitution so as to go and scavenge for an escape route under the Constitution? No. Actually, the purpose of the provision in Section 5 is consistent with the Constitution. The Constitution provides for rights and obligations on both sides. The rights of the accused, the obligations of the state. The obligations of the state include, among others, respecting judicial process, respecting laws of the country, including the Extradition Act. How come they have never made a reference with respect to the Extradition Act if they think it was inconsistent?
It is essential. Raising 3 broad complaints. One, it is raising issues, my lords, of extradition. And the charges that were subsequently slapped on him outside the offenses, the offense with which he was extradited. Secondly, my lords, is raising issues of unlawful detention. And finally, the third broad aspect being raised in this affidavit is the aspect of torture. My Lord, I will just briefly take you through the facts. I do associate on the issue of extradition, the jurisdiction, and the position of the law as argued by Medad on behalf of the first and second applicant. I fully associate myself as the correct position of the law. And equally, those parts where he was addressing the aspect of the law on jurisdiction and extradition, would be pleased to adopt them on arguments of the law for the third applicant. In terms of facts, the evidence in support of that, my Lord, I invite you to look at that affidavit, paragraph 8. The gist in paragraph 8, 9, 10, as you go down, is circumstance surrounding arrest, but what you may highlight is that he was arrested on the 15th of March 2015. In Tanzania, at a place he calls in paragraph 18 Kahama. And my lords, it is his evidence that when he was arrested and detained on charges not connected to the charges with which he is facing. The applicant, through his affidavit, also indicates that on 4th of June 2015, he learned that the government of the Republic of Uganda had filed extradition proceedings against him. In the resident magistrates court of Dar es Salaam, seated at Kisutu. The application which was filed on behalf of to have him extradited was application number 15 of 2015. That is clear in his affidavit, my lords. My lords, the extradition, paragraph 12 is instrumental, my lords, paragraph 12 of his affidavit. The extradition proceedings were based on a warrant of arrest issued by the Chief Magistrate's Court in Liga. And it was with respect of one count of murder. In paragraph 14, he attaches the proceedings and the rulings